Hi, my name is Kim Cullen, and I'm a personal injury attorney in Winter Park, Florida. One of the more unusual questions that we receive in our office is from someone who calls and asks us if they have a case for negligent infliction of emotional distress. So negligent infliction of emotional distress is a very unique cause of action. It's not the same as intentional infliction of emotional distress, and we'll shoot a different video to discuss what that cause of action is. But negligent infliction of emotional distress has been around for a long time, but it has certain characteristics that make it a unique or unusual sort of personal injury case, and probably the most important aspect of it is that it doesn't necessarily require you to have a personal injury. The classic case law that established negligent infliction of emotional distress required that there be some physical impact to the person who's suffering from the emotional distress, even if that impact didn't cause a serious injury. So the example might be two people are standing on the sidewalk. It's a father and daughter. Let's say there's a crash or somebody negligently gets off the road and kills the father. In the old days, the daughter wouldn't necessarily have a claim unless there was a physical impact on her. Let's say, for example, the side mirror from the car that crashed into her father flew off the car and hit her. That, under the old case law, would be enough for her to have the physical impact necessary to pursue a claim for negligent infliction of emotional distress. So she would be able to actually recover damages for the terror that she suffered seeing her father hit and killed, but she couldn't have done that unless there was some physical impact to her. So over the years, that negligent infliction of emotional distress cause of action has now evolved so that the physical impact or physical touching doesn't necessarily have to happen. There's still a physical element to it, but it's not the same as that. So under the more modern case law that's come out or been decided by Florida's courts is now the physical touching or the physical manifestation is all that's required for there to be a case. So for example, the same example I had before, two people, father and daughter, standing on the sidewalk. Father gets hit, daughter doesn't. But daughter has an emotional reaction to what she's seen happen to her father, and that emotional reaction manifests itself in a physical finding in her body. That now has been determined by courts to be enough to support a claim for negligent infliction of emotional distress. So that's an important distinction, and we actually just handled a case where we had a really good result for our clients who were daughters of a gentleman who was killed in an accident. They were nowhere near the accident when it happened. They came upon the scene later after they had heard that their father had been involved in this horrific accident. When they arrived, they saw him on a gurney in a body bag, and they both had very, very emotional reaction to it. And under those facts, we were able to convince the insurance company for the person who caused the accident to compensate our clients for negligent infliction of emotional distress. So the driver negligently inflicted that upon them. Now, the way that the case law is evolving, it's not even necessary that the physical manifestation happen at the scene of an accident or near in time to the scene of accident. It can now happen weeks or months later. So that's an important distinction that may impact the viability of a case sometime in the future. And again, these cases, every couple of years, a new case will come out where the courts will look at this situation again and tweak it a little bit. And so it's very important for me to stress that these cases are very fact-specific. So if you have any questions about a negligent infliction of emotional distress claim or a potential one, all you have to do is call us. Our office line is 407-254-4901. You can always text us at 407-644-4444. You can email me to my personal email address, kmc@cullen-hemphill.com. If you have questions about issues similar to this one, you can find hundreds of videos on our YouTube channel or hundreds of videos, blog posts, and legal articles on our website at www.cullen-hemphill.com.